The judge had clearly read all the documents and the files, and he, I think, has a good sense of what the legal issues are about. And so we'll just see what he comes up with. I anticipate with something this important, he's going to take it under advisement, go back to his office, look everything over, and make a decision at that time. So that did not surprise me at all that he said he'd take it under advisement.
I guess I wasn't surprised. I know that the judge is going to take a deliberate approach to looking at both sides of the argument. I was a little disappointed that we weren't able to get an immediate ruling, but we're still not enjoined from doing anything.
I hope the judge is going to rule in our favor and get it so that we have a fair election, and that the people who are making all these inaccurate statements relating to the effects of Measure 2 are forced to at least tell the truth and have a basis for it, of what they're saying. And it's clear, some of the things they're saying, the Measure 2 says the exact opposite. So it's rather frustrating from the proponents of Measure 2 to hear these people saying, well, this is what's going to happen with Measure 2, when the text of the measure itself clearly says that's not going to happen.
I think that in the study of this case, the judge will rule in our favor, and we will be allowed as elected officials to give our opinions and to educate the public on what the impacts of Measure 2 will be. And they are significant, because this has never been done anywhere else in the country. And so county officials, if nothing else, are saying we need to be really cautious about this measure, because we have no idea what will happen.
There's two types of laws. There's criminal and civil. This Corrupt Practices Act has a criminal provision which makes it illegal to do these things, and it's a Class A misdemeanor. But it also has aspects of what things are also illegal that we assert can be used in civil court. So what we did today is we had previously made a motion to ask the judge to issue a temporary restraining order to prevent them from doing this anymore. The judge had oral arguments on that today. He already has our briefs. He has the summons and complaint, which describes what we think is being done illegally. He has an affidavit from Charlene Nelson, the head of the Empower the Taxpayer group, and he has that as the evidence he needs. And today we had oral arguments to determine if the judge is going to issue the order we've asked him to issue. And he can do lots of things. He can say no, he can sidestep the issue, he can say I want a hearing. Obviously we prefer that he'd issue an injunction or a restraining order telling them to quit doing these things. The statute can be enforced criminally by a state's attorney who determines that they think somebody should be charged. We're attempting to resolve this civilly in regards of saying you're violating the law and please don't do it anymore. And that would be injunctive relief within a civil process.
That doesn't concern me so much, because there really is not a criminal situation here. It is definitely an opportunity for public officials to be able to help educate citizens on this measure.
They're asserting that the Empower the Taxpayer Committee is attempting to prevent them from talking about these issues. That's not the case at all. They want them to talk about the issues, but they don't want them to present lies, which is illegal. Number one, the law says that public officials aren't supposed to take any position, and that they're only supposed to provide information and not tainted information or mischaracterization. The law is section 16.1, 10, 02, and 04. So those sections of the North Dakota Century Code have been there for a long time, since the 1970s, the part about lying. But the part about not taking a position on a measure was just passed the last legislative session. And yet some of the people who actually voted for it are out there providing misinformation. The other problem is we have at least 3 Attorney General opinions that tell public officials you can't do the following things: mischaracterize things, provide only a misleading one side of it as opposed to the other, and they're all, many or most of the defendants are doing things like that.